Hi, and welcome to this episode of Beyond the Gavel. This is the podcast where we step away from the courtroom, that we can look at how law actually is practiced at the coalface, where judgment, empathy, and evidence all intersect. Because today's conversation is with Emily Trieber. She's a medical malpractice attorney with Syria Grimstead, and that's in the United States. And her career sits a particularly interesting junction between healthcare, public health, and litigation, because her professional journey didn't begin in a law firm, but in the frontline EMT. And thank you for your work. I mean, it's really, really important. We all know how important that is right at the coalface. But what that's given her is something different. It's given her an understanding of public health, of EMT, and how it works, how clinicians think. And she did her public health training in Dartmouth and now into the complex medical legal practice. So it's not simply her advocacy for the injured patient, but her understanding of the systems. And that has helped prevent, she knows that good communication helps prevent a lot of cases long before they reach a lawyer's desk. So she has to manage the firm and also leading sensitive, high-stakes litigation involving catastrophic injury in vulnerable populations, including older adults. So in this episode, we're going to explore how empathy and objectivity coexist, how they can work together in serious clinical cases, why early screening matters more than most firms appreciate, and how lawyers can navigate that fine line between outcome and true negligence. So we also discuss maybe a little bit about leadership, mentoring young lawyers, and what thoughtful medical legal practice should look like over the next decade. So this is a measured, reflective conversation about responsibility to clients, to the courts, and to the healthcare systems that we all depend on. So I hope you enjoy this episode. Emily, welcome to Beyond the Gavel.
Thank you very much for having me today.
Oh, it's such a pleasure. And I mean, just when we talked earlier on about your whole pathway as it went through there, how has your pathway going from emergency medicine into public health and then into litigation, how has that affected you to distinguish between unfortunate outcomes, which happens, and a lot of lawyers don't realize that unfortunate outcomes do happen, and then true negligence? How has your background helped you to work out between those?
Great question. Well, I would say first off, as a first responder, you get called when it's someone's worst day. No one calls 911 when they're happy, they're celebrating. They call you for emergencies, terrible events that have happened. So it allows me to kind of have a background in seeing harm, seeing catastrophic injury, seeing, devastation, and realizing that when you take a step back and you see the whole scene, there's a lot going on. So for someone who's been impacted, they've had this event happen to them, they've had this care gone wrong, they may feel that, something is wrong, something negligent occurred, an error was made, and that's why they are in the position they're in. But having the EMS background, having a medical understanding allows you to take a step back, see the whole landscape for what it is, and be able to investigate the harm, what led to it. Was it just a natural downstream or a natural consequence of the disease, or was there an event or an omission that happened that led that person there? So it really just gives you the general feel to be able to see the landscape with a clear lens and a steady
What
head.
you're saying, there's empathy, but there's professionalism as well. I mean, let's face it, we can all feel for people, You can't really sympathize because, one, you've never been in that position yourself, I hope. But two, it's a bit blasé to say, oh, I understand fully what you're doing, because we don't. But at least to make people feel they're listened to. So how do you balance the empathy and your professionalism?
Absolutely. I think they go hand in hand. So I always try and practice and meet someone where they are. So I come to them from, a position of trying to understand, trying to gain their perspective, but trying not to blend sympathy with empathy. They're two separate, different components. And so while I can empathize, I also need to wear my professional hat that there's a lot of different components going on that led them to where they are and why they're in my office or why they're calling. So I like to be cognizant of the fact that they're feeling a certain way because of what's happened to them, and I need to be respectful of their perspective and their feelings, but I also need to maintain that professional boundary. I don't want to mislead them and make them think that there is a greater wrongdoing or a potential case when there may not be. I want to make sure that I'm, maintaining a professional boundary with regard to also evaluating their claim and listening to their story, essentially.
Yeah, listening to their knowledge, everything. And I think you had a very good word there called respect. It's respecting what they believe what they believe. I mean, and they come in. Unfortunately, a lot of people go to the lawyer first off to get a second medical opinion, and they hope they'll pay for it. But they actually believe they've been harmed and that somebody must be responsible for it. So we have to respect that and then handle it in different ways. So in your office, who speaks to these people first? Who speaks to before clients become plaintiffs? Who speaks to them? Who talks it through with them? How do you handle when they first turn up?
Yeah, so in the firm that I'm in currently, a lot of times the first person of contact will be a paralegal. They'll gather the information, just general facts, timelines, things of that sort, area in which, the location in which the person resides. And then I will generally review the information, review the facts, have a conversation with the individual if the facts so necessitate that, and make a determination that way. In other practices, I'd be the ones getting the call, screening, listening to the person, getting their facts, and kind of making an on-the-fly determination as to whether I thought there was validity that necessitated further investigation. So it's really firm dependent, but in my current firm, it is generally paralegals and then attorneys kind of work in tandem.
The paralegals, I mean, you're very much into teaching and training. You point out you had a lot of people leading you. What have you seen about how do you lead a team like that? How do you teach new people in? How do you teach your paralegals to deal with these cases without getting themselves sucked in?
And so I've been in a lot of different experiences where, the paralegals have a lot more knowledge, and that's true here. I work with great paralegals that have come from tons of years of experience. They have been doing this longer than some attorneys have been practicing. So a lot of it is just tailoring them to what you're looking for. Sometimes I'm looking for collecting certain information, or I want them to approach certain situations with a little bit more consideration or a certain tone. But I would say that for my team, they're all highly qualified. They know exactly what they're doing and they came with the experience. So there's not so much guidance that I really have to provide. They're really high performing and achieving individuals that I respect. I don't really need to oversee them too much, but I have worked in areas where, I have to provide SOPs or guidance as to exactly what they need to do. And they required a little bit more oversight, but that's certainly not the case here.
Taking us out of that particular law firm, that any time that you've had to give feedback, that you've had feedback which wasn't necessarily positive, how have you handled that with the individual?
Yeah, so I like to just have a candid conversation. I always like to start with something positive. I never want to go into just making someone feel like they have to be on the defensive right away. I like to highlight something positive that they've done and then maybe bring up a specific example so that they may not understand what happened, but I can give them an example to show them and illustrate kind of what the action was or the inaction. Give them an instruction as to what the corrective or appropriate behavior should be so they know what they need to do in the future. And then ask them if they have any questions. I like to make sure and close the circle of communication so that they know and they're on the same page that I am. And so there's nothing that really fell through the cracks communication wise. I was clear, they understood me, and we have a pathway forward.
So to be clear and to do it in a timely manner is not important.
Oh, absolutely. You don't want to let anything.
I know people that just hide in the background and say, I don't want to handle this. And then they get 4 or 5 complaints about the same thing. Right. Whereas if it's talked about generally up front, in, as you say, a non-judgmental way, you're saying, this is a fact that happened. So, let's just, how would you deal with it? How do you think you should do this? Do you say, I'm getting from them their point of view and getting them on board? So I love the way you think on that, instead of saying you're wrong and do that. And what's interesting is we have this curve, don't we? We have the paralegals who know what they're at. You're right. Then we have the new lawyer who's fresh behind the ears and said, this is the law, and oh my goodness, I'm here to save the world. And you get this dip in communication before they twig on. So a lot of times it's not the paralegal that's the problem. It's the new, wet behind the ear lawyer. How do you work with them?
Yeah, so I mean, sometimes it's just the natural progression. who hasn't been new and made an abrasive email or started off too strong or really just thought their case was extraordinarily superb until a fact comes out later on and you realize the shortcomings. So I think a lot of it's trial and error, and you need to get those lived experiences in order to not make those mistakes again. And I think any practicing attorney can say, I can empathize. We've been there. We've all been new and we've all had those experiences. So sometimes it's just guiding them gently through it, but they need to understand and get those perspectives from that experience. You could tell them you're blue in the face sometimes. They just need the lived experience.
Experience counts for a lot, doesn't it? I mean, we talked before about, my background in Belfast with the defibrillators and things. And one case I remember, particularly in those days, right in the 60s and early 70s, a doctor and nurse would go out with the cardiac ambulance. It was called the cardiac ambulance because it had paramedics weren't there at the time. It was scoop and run. And I remember going out to someone and they had a particular type of myocardial infarction. And I had got them around and brought them back in, and the family came in afterwards, and I'd gone to speak to them as a young doctor, still very wet. And I'd said, look, everything's going to be fine. He's 45, strong guy, we've got him, it's all going to be. And I wasn't finished the conversation till the arrest bleep went off. And he arrested and died. And I had been, I learned a big, big lesson that day. Do you know what I mean? Not to overdo it, not to just kind, stay in the middle, state what is reasonable to state, and don't give reassurance when it's not there. And in your practice, it'll be not telling people, oh, we got a brilliant case here. Yeah, we'll handle that. And then have to turn around afterwards, which is awful to say, no, it doesn't. So have you seen any things like that?
Yeah, we see that a lot. I mean, and at the end of the day, I like to tell clients is you never know what a jury could do. You could have a slam dunk case and you get in front of a jury of your peers and they may not feel the same way about the valuation. They may not see your harms as being as devastating as you do. And they may not allocate an amount or even a judgment in your favor. And that's the realities of trial is you could have a great case and it may not be the best jury pool for that case. And so there's never any guarantees. And so when you prepare a client for litigation, if all pre-litigation settlements and negotiations have failed, it's your duty to then kind of inform them that it's a risk. There's always a risk with trial. There's never a guarantee. And to set those expectations that, you're going to work as hard, you're going to zealously advocate for them. But at the end of the day, you can't guarantee any outcome. I mean, that's kind of the important thing is it takes time and money to get to that jury. And you may not walk away with what you think you will.
No, and it also helps a wee bit. You've got a bit of leverage there in the negotiation bit where you say, now listen, you turn this down and we'll have to go to court and that might not be in your favor. So there's a little bit, maybe it's fair or unfair, but you can kind of lean a bit because you have the experience of knowing what a case generally is worth. No, we don't know what a jury's going to do at the end of the day. But say, what percentage of your cases would go to trial?
So I'm in an interesting jurisdiction. I practice generally in Rhode Island and Massachusetts. And in Rhode Island, many things settle pre-litigation or before a trial. So not many things go. I would say about 4 or 5% of things go to trial. It's very rare that happens. And I'm now at a firm that is national. We represent clients all over the country. And we're seeing that many of those cases will go to trial. Different jurisdictions, different venues. Some of the defense counsel, they're motivated and incentivized to bring things to trial. So it's very different being in a nationwide practice. So we will see a lot of trials.
And med-neg, I mean, most of the world, they want to get it settled before they go to court because those awards generally are higher because the defense normally doesn't want to go into court, if they're going to lose. So they'll go to court if they think they're going to win. So how does that balance out? Why do you think these other jurisdictions want to go all the way?
And some of them have caps where you're limited in your economic damages. So why pay the cap if they could be limited by the cap and you'd have to bring it to trial? So in those jurisdictions, it's a little bit harder. It's more of an uphill battle. They have kind of the upper hand. But in some of them, depending on, I think, the contract with the insurer and the provider, sometimes the providers just don't want to settle. They don't want to authorize a settlement. They don't want to accept that they did anything wrong. And they'd rather have their day in court, which is their prerogative, generally, depending on their agreement with their insurance company. Sometimes they make that decision to kind of push the case forward and not offer a settlement or not agree on a value for the case. So we have seen that in certain occasions.
Yeah, trying to get the other side to say, and that's a lot of times that's about relationships. And there's a problem there, isn't there? Because you have a relationship with the other side, i.e., the person who's doing the defending, the trial lawyer on the other side, but not with the insurance company. They have something with the insurance, but you don't normally talk to the insurance company. Although within a particular jurisdiction, some insurance companies are preeminent, so they get used to who the plaintiff's lawyers are. And that sometimes, I'm told, is easier because they know you from other cases. Whereas in bigger jurisdictions, they don't. And it's just a big edifice of an insurance company versus who the heck's this defense lawyer? Who's the plaintiff's lawyer? You know, they don't know. So there is a matter of that relationship building. Do you spend a lot of time building relationships with defense lawyers?
I wouldn't say that that's generally where my time is spent. A lot of time, their duties are a little different. They have a fiduciary duty to a different individual, and their benefits different. So they can send an email and bill for it, where they're kind of inclined to sometimes bill up the file because that's how they make their money, is the more the case goes on, the more they can bill. So they're incentivized differently. Of course, I think it's important to be collegiate. It's important to be professional and be respectful. Whether or not we're adversarials, we can definitely, carry on conversations in a respectful manner. So I think that that's always the approach that I take, but I'm not trying to foster or build necessarily relationships because I see different defense counsels all the time. I'm not just in one jurisdiction where I'm continually against one.
Well, that would be because your professional experience is wide over many states and you have all that wide experience. Right. So that's what you bring to it. You it's not just that you're in sort of Rhode Island, but you're moving down to Charlotte soon, aren't you? And there's that jurisdiction, Carolinas and all the rest. Is it mainly East Coast or do you go out towards the West?
We are all over the country. So we have cases in Arizona, Illinois, all over.
Your private jet must be out of fuel.
Taylor Swift and I are flying in tandem.
Yeah. Well, tell me then, what percentage of cases that come in over your door do you reckon are worth it? I mean, people walk in over the doors we've already discussed. They think they've been badly treated, but legally it doesn't rise to the negligent act. It's a poor outcome, but not negligent act. What percentage of cases do you reckon comes into your company that you would have to say that's not a case, and it's not a case we're taking on?
So I would say, a fair number of them. I would say, if we get 10 in, I review all of them, but then I'd say that about 5 or 6 have validity. I'd review them further, request further medical records, do more of a deep dive and investigatory analysis. And then I'd look at the medicine, the legal claims, and about 2 or 3 of them, maybe then I'd send to a medical expert. And then they would tell me, and probably about 1 or 2 of them, we'd say, hey, let's engage this client. We have the medical backing and expert supports our theory. And we feel like it's a viable claim where the damages also reach a threshold, because it's an important balance of, it is a business. We want to make sure that we're not expending expenses left and right without any kind of recoupment of those. So it's kind of a nice, gentle balance between, if there's validity in the facts, can we support it? And is it economical and feasible?
And that has to be brought up for everybody. I think people coming out in my talking to young lawyers and things like that, they don't get it, that it's a business and it has to have a return for all the work and effort and time. Okay, lawyer sits and puts their time up, but then you've got your ancillary staff time, you've got the staff time, the hospital digging out records, you've got staff, everybody involved, in a lot of time and emotion expended. And it's got to be that there's something at the end of it that makes it a reasonable call. And it's very funny you give that figure, because around the world, it's exactly that. 80 to 90% won't. They just are not going to get a successful outcome. Correct. But the 10 to 15%, those are worth it. And you can really spend your time and effort doing that. So I think it's fascinating how that works in every jurisdiction. The numbers are about the same. Let me ask you a little bit about AI. Are you using AI at all, or what are you seeing amongst your colleagues with the use of AI?
Yeah, so I have worked at firms where they have their own AI built into it. I know defense uses it a lot. In this particular practice, we're not heavy on the AI. I'm a pen to paper kind of girl. I like a paper record. I think there's nothing that replaces your own perspective, your own reviewing of records. I think it's a little premature to be relying on, a computer to review and do analysis and do a chronology. I think you kind of disservice yourself. You're not gaining the perspective and the insight that you need to fully evaluate a claim and to be able to negotiate the claim with the full understanding of all the injuries or the issues or the treatment. So
Well,
I
that's
feel at this
important.
point
That
I'd be doing this
understanding is
service.
very important for you when
Right.
you're advocating for somebody, that it's not just this says or that says, but I have read it and I understand.
Right.
So where's the expert in this? I mean, you've just pointed out you need to understand what the medical evidence is. So what's important to you from a medical expert?
So it depends on each case. So depending on the case, I'd want to find someone that, has great credentials, has an understanding, has practice. Some jurisdictions require that they've practiced in that particular area in a timely manner, sometimes 2 years. So it's jurisdictionally kind of dictating who you'd use, but someone that can give the plain language to a jury. They can break down the medicine in a way that's understandable, it's engaging. They come across as more of a person rather than just a figure for the plaintiff to get their story across. So it's really important that they have a personality that has some charismatic features to it. They understand the medicine, they're qualified from their education and training, but they also are relatable. I think that's huge. You can't put someone in front of a jury that's going to sound like a robot and bore jurors with, neuropathy or the pharmaceutical downstream of complications if you don't bridge appropriately. There's just so much medicine that goes into it that if your expert's not relatable, they're not likable, and they're not able to communicate clearly and easily, you're going to lose the jury on those important matters.
It's not a lot to do with ego, really. And again, it's a communication skill. Can you teach communication skills, and you went into medical schools to teach them? What did you find when you were doing that?
So during my master's of public health, I did a lot of research as to what our ACGME or our graduate medical education, they require professionalism and communication to be taught, but there's no real, I guess, process for doing so. There's no book you can look up and say, this is how this school is doing it. Schools are just kind of essentially winging it and trying to make those achievable activities that are occurring. I'm not quite sure that there is a set way that you can gauge how a particular med student or resident communicates other than putting them through different kind of activities, putting them in front of actual patients, and then giving them feedback in real time. There's simulation labs that they allow them to relay certain information based off the case. But I think being in real time and challenging these providers to communicate with empathy, to communicate transparency, and to communicate at an understandable level, which is most people have a grade reading level of I think it's 6th grade. So being able to be easily understood, that's part of the component of communication as well. So that was a big part of my research is, how are they communicating? How are they being understood? And how are they being taught to communicate important information to patients and families?
And how do you find that's happening between the generations? Do you think that's changing in the way that the present generation communicate and that older generations communicated?
Yeah, I think it's kind of comparing apples to oranges. I think this generation is up against administrative burdens where, you have to type out documents and do appeals to insurance. So they're getting less patient contact hours. They're getting less time in front of the patient. They're having more patients being required to be seen in a shorter amount of time. So I think the practice of medicine is kind of traversing in a different direction that doesn't necessarily encourage patient-centered care, patient preferences, patient-informed care, which are all so important and fundamental in safe care. But I just don't think that the newer generations, has the communicative skills that a lot of the older practitioners do, but they also don't have the time to foster and grow those skills.
Yeah, when we were training, I mean, patients I was in many, many moons ago with my tonsils being taken out as a child. My parents were allowed twice in a week. You went in to have your tonsils out, you're in for a week.
Wow.
Parents were allowed there twice in that week, and you were in hospital for that length of time. So it meant you spoke to a lot of staff
Yeah.
because nobody else to speak to. But nowadays, you're in, day case, out. You're reviewed if necessary. So even a gallbladder that used to be in for a week, 10 days is now a day case. You know what I mean? So they're not getting the experience of talking to anybody. It's a matter of tick the box, did they consent? Yes, in, done, out. And remember to tell them that if something goes wrong, phone this number. So yeah, I think that there's an awful difference coming. And AI is part of that, because AI should make things a bit easier, because AI has a very long tail. I mean, if I know this amount about a drug, that's the central portion. AI knows everything about the drug. And it can tell, different features of a drug that I haven't actually thought of or seen before. But the other thing that AI does then is it quickly makes decisions, tells you to do this, tells you to do that. And once you become dependent on it, and it can speed up note taking and all the rest of it, a lot of hospitals that I've seen in the United States turn around and say, okay, and then you can see more people, because AI is going to do this. So you can see more people. So instead of saying there's a benefit from AI, you have more time to speak to somebody, they're actually saying, no, AI is a benefit to us, the institution. You can see more people, just like you're saying. And it's still that same, grind, keep going, just thresh them through. Are you seeing any of that in the law, the way the law is turning out?
I think AI has been a little slower to catch up with law, and I think there needs to be a delicate balance, because it never can replace the brain. It shouldn't be replacing your cognitive self-awareness or your dissonance or your ability to make decisions. And I think it can be an aid, and it can certainly help you uncover all different options, and it can give you some insight. But when it starts making those decisions that are imperative to be made by a human based off of human interactions, I think that's when we're going down a slippery slope. The AI is tied into certain case searches where you can compare briefs, defense briefs, your briefs. It'll pull up cases. That's great. It saves you a lot of time in motion writing practice, and helps increase your oral advocacy skills if you're able to get access to that information quicker. But as far as stepping into the legal role, I'm not quite sure what role AI will have, at least at this point, apart from using it in like case searches and things of that sort. I think it would be very perilous to use it in lieu of like an attorney's own intuition and perspective.
Yes, there is a lot about that. I mean, I recently looked at a case where AI said the doctors showed indecision and therefore delayed, whereas when you read the thing, they actually had a multidisciplinary team meeting and they decided not to do something for a few days in order to see if something else occurred. But AI interpreted that as indecision, and started a whole thing about delay due to indecision, and it wasn't. So you're absolutely right. But that's the way it's going, and that's the way the younger generation are. So we have to take everybody where they are, don't we? In fact, now I will bet you that Dr. GPT is coming in, and the patients turn up at your door, and you just read the missive they're giving you, and you know very, very well this has been through the AI to come to you and said, and you should check this and this and this. And you're going, oh dear, oh dear. Now then, what do we
very
do?
frequently.
It used to be Dr. Google, now it's Dr. AI, but there it is.
Yeah.
Emily, this has been a wonderful chat, and I think a lot of people will have got a lot out of that. Your background in medicine has given you, a clear idea of the understanding between, different types of outcome. Fault is not necessarily there, and your judgment, your intuition from your experience is so important, and we shouldn't just delegate that to AI. And the other thing you have is your experience, your company, over multiple jurisdictions throughout the US. And that makes you a very powerful advocate for your company and for your clients. I appreciate you coming on, and thank you so very, very much for the conversation today.
Thank you very much. I'm grateful for your time.